Hi, everybody. Woo! Hello. My name is Danielle. I'm part of the IGDA Toronto Steering Committee. Yeah, Danielle! Thank you. I can get used to this. Thanks for coming tonight and joining us for Lessons in Video Game Law from our ACE attorney. Tonight we're going to look at some issues facing games industry professionals, and afterwards we're going to have our social at Jack Astor's, so stick around for that and for some networking. Before we get started tonight, I want to take a moment to thank this season's sponsors: Ubisoft Toronto, the City of Toronto, Get Set Games, Massive Damage, Big Viking Games, and Media's Law. We're really excited to have these sponsors on board, and we want to thank them for their contribution to the chapter. Without further ado, I'd like to introduce our ACE attorney for this evening, Emmanuel Evdemon of Media's Law. Emmanuel is a video game enthusiast of many years, and he's a huge supporter of the indie development community, especially in Toronto. He's worked in entertainment law for over a decade and as a lawyer since 2005. He began his career in film and television and now has a strong portfolio of clients in the interactive digital media and video game sectors. He's spoken at both X Summit conferences, guest lectured at U of T and George Brown. He's been a guest on the radio program Got Game on AM 590 and has chaired and organized numerous programs and conferences with the Ontario Bar Association. Emmanuel has also generously agreed to come on board as a bronze sponsor for this season, and he's donating a legal session as part of his sponsorship. So if you'd like to enter into the draw for this complimentary session with Emmanuel, please visit the IGDA Facebook page for details on eligibility. Emmanuel is going to be fielding questions throughout the presentation, so feel free to put up your hand and ask him things. Or if you don't get a chance to ask your question here, we're going to have a bit of a Q&A after his session, and then if you still don't make it in, you can go up to the microphone after the session as well. And if you still can't get your question answered, come to the bar and you can talk to him there. So there it is, take it away.
Hi, my name is Emmanuel Evdemon. That is an awesome picture. Tim, if you're that rocks. And I do actually own that tie, but I wore it I think once in the past 10 years. So I apologize that you guys all have to be here for talk about law stuff. It is boring and it's unfortunate, but it is a necessity for doing business. You have to go to the doctor to get your checkup before you go, or your shots before you go on vacation. You really should talk to a lawyer before you start operating your business, just to make sure that things go as smoothly as possible and you don't get nasty bugs. So that being said, we'll try to make it as fun as possible. By all means, any questions you have, any heckling you want to do, go for it. It's all good. It will probably keep some people awake. So let's. What I wanted to start with is sort of this daunting task that faces a lot of people. It's like, well, how do I find a lawyer? And how do I go and how do I choose a lawyer and how do I meet with a lawyer and what do I do? Because that's frankly what a lot of people sit there and have a difficulty with. And how do you find the right lawyer? So one of the things is I'm gonna walk around here. Hopefully we're not gonna get any feedback or anything. Far and away the best way of finding a lawyer is talking to your friends and your colleagues who are in the industry and people who have worked with that lawyer. They'll be able to recommend, they'll have an idea of your business, they'll have an idea of their business. Definitely the best way is to get a referral from a colleague or a friend. LinkedIn, another really good example of a source for finding legal counsel. You can really, I find you can customize your search a lot better with LinkedIn, find out their areas of practice, and find someone who's really geared towards your area of work. For instance, you might be doing something more obscure like music royalties, and LinkedIn would be a great source to help you find lawyers that actually have that in their area of practice. Google, it gives you a crap load of information, so it's always a lot more difficult to find and siphon down the answers. Unfortunately, we don't have advertisements like, hey, are you building a video game? Yeah, talk to this guy. Just there's not that many of us out there in the entertainment field. Associations like the Law Society of Upper Canada and the Ontario Bar Association, they are also good sources, but I put them sort of down at the bottom just because, again, entertainment law, it's a very small bar. There's very few lawyers, and so you don't find as much marketing and as much access to them through some of the other organizations, but by all means, the IGDA, Interactive Ontario, they're excellent organizations. Even the Hand-Eye Society, they might have an idea, and if they don't, then some of the members will, for sure. So once you've determined, okay, these are the lawyers that I'm sort of looking at, look at their websites, look for the areas of practice that include your specific needs. What kind of work you do, it should be reflected in their presence. And you can look at any publications or speaking engagements that they've had, and then basically call them. Call up the lawyer, email the lawyer, however you want to reach out to them, and get an initial consultation. Okay? It's not a scary thing. You'll sit down and talk to somebody. We all do that. Make sure you talk to them about your needs. Make sure you communicate what you're looking for. What is it that you're facing? Make sure they know that, and see how they deal with that. See how they deal with the specific questions that you want to ask. By all means, especially for indie developers, our pockets aren't necessarily that big and deep, and so it's a very relevant question. Are you going to charge me for this? Are you going to charge me to come and talk to you? Even just an initial conversation. Some lawyers do, some lawyers don't. Ask them, straight up. There's no harm in asking. What's the worst that they could say? Yeah, I charge you. Okay, well then, we'll decide based on that. Ask them what the rates are. Find out how much things will cost. So sometimes there's some things that you'll be able to get a flat fee for. Often it's just simply, it's going to take hours and this is how much you're going to be charged per hour. But ask. There's no harm in asking. Get all the information up front. Don't be scared to ask. One other thing is, get a feel for the lawyer. Ask them the questions and know that you know your business better than they do. So as much as there's this inclination that a lawyer should really know everything, they don't. And that's okay. It's entirely all right. I will never tell my clients how to build a game because I have nowhere near that technical knowledge. I'm sure there's some lawyers who do, but I have nowhere near that. I've gone through a lot of negotiations, often more negotiations than my clients have. I'll have great insight on those areas, but I definitely won't have the insight, the technical insight on the construction and the design of a game. But that's okay. That's why you're working in a team with a lawyer. Take your time to go through all these questions and make sure that you get a feel. This is it's an intimate relationship you have. This is someone who is helping you with your business. You're putting a lot of trust in this person. So make sure you're comfortable with them. That said, don't waste the time. I have one experience now. I should have got a clock here. I think we're doing that. I had a terrible story that once we got a call from someone who's like, hey, I've got a great idea for a movie, and it's a big movie, and I'd like to come in and talk to you guys. And so I was with a partner of mine, another lawyer, a few years ago, and we had this gentleman come in, and he showed up, and well, I think he might have had something before he got to the office, because I think that's kind of what gave him a rush, and he came into the office and was like, it's a great, great movie. What is it? It's awesome! Great. Here's the title. And it's in the Star Wars font. Excellent. That's about when the first lawyer excused themselves, and I thought, well, you know what? I have another 5 minutes. Let's see how far this goes. I got another slide. It's really, really cool. And he proceeded to pull up the R rating. Wow. Do you want to make copies of these? Oh yeah, definitely. That, not so much. Otherwise, relevant questions, by all means, go in, talk to them. Accessible people, what's the worst they could say? No. So what are some of the issues that you guys are facing? How many people here are game developers? And how many people here are creatives that contribute to game development, audio, animation, design? And how many people are involved in that other field with the big box and the TV converter and stuff? Any television people here? Good, good stuff. So I'll focus this towards the interactive side. I'm not sure how many of you guys have played this game.
Which one?
The original, the ridiculous one? Or, wait, sorry, was it? Not the ninja. The extreme fishing. So this is basically what happened in July of 2010. Vladimir Games comes out and they're watching a documentary, and they decided it would be really, really cool to make a video game about fishing, tuna fishing, I think it was in particular. In November, they published Radical Fishing. There we go. On board.com, and they decided at the same time, okay, we're going to create an iOS version of the game, and we're going to call it Ridiculous Fishing. In July of 2011, while working on the Ridiculous Fishing iOS version, they get wind of Game Knots, who turns around and releases a trailer for their upcoming iOS game called Ninja Fishing, which was extremely, extremely similar to the first version, like ridiculously similar. Between July and August of 2011, there's some interchange between the two companies, between Vladimir and Game Knots, and well, how can we make this work? How can we release our games? I think the last thing that Vladimir said was, you guys hold off, we'll release at the same time, and we'll let the quality of the game go. And the last response they got was, we released yesterday. Not cool at all. They were super discouraged. They dropped the game for a while. Then in January of the following year, they released another iOS game, Super Crate Box, which I haven't played, and they decided to go back into production for Ridiculous Fishing, which, under the name Ridiculous Fishing, you can't find on the App Store still. So how does this happen? How is this possible? You have this company that made this great game that's really fun. How can someone come over and just rip it off entirely? Well, when we look at copyright, it's and what gets protection in what we do, it's not the idea itself, but it's the expression of the idea. If we were to copyright ideas, then it would be a big mess, and I'd come up with this idea. Oh, I have an idea for a flying car. Now, nobody else can do that. Nobody else can do that. Flying car. Forget about it. And that would be really hard to enforce, and that would also kind of stop creativity pretty quickly. So, what was the response? We're gonna protect the expression. So, in order for your property that you guys are creating to be protected, you do have to fix it, make it into a paper format, make it into a tangible format, and that's when it gets protected. There's several ways of going about that protection as well. You can register the copyright in it. That can be really easily done actually through the Canadian website cipo.org.gc.ca, I think. And the US Copyright Board is actually even better because you actually submit a copy, a digital copy of what you're protecting. And so if there's ever any question, well, you have a digital copy that was submitted and they're able to actually verify and check and to see what was created by you when you registered and what was created by somebody else that we're contesting. What do we look for? We look for substantial copies. When we're trying to determine a copyright infringement, you look for a substantial copy, and that doesn't mean that it's like a whole lot of whatever work that you created that has to be copied for it to actually be an infringing copy. It just means it has to qualitatively take the essence of it. It has to be a meaningful part of it. And so it's not necessarily, oh, they only took 4 lines out of that song. Well, those lines could have been the whole essence of that song, and you can turn around and say, well, no, that is a copy. And then one of the other things we're looking at is in establishing an infringement and being able to sort of show that this really was a wrongdoing. You have to demonstrate access, and you want to be able to show that someone else saw what you did and copied what you did. Because 2 people, they don't know each other at all. They could have the same idea. They could go about it, especially in an industry of ones and zeros. They could really very easily go about it the same way to creating a very similar, if not identical, property. And both of those people would be entitled to protection for their original work. What we need to do then is we need to demonstrate that someone didn't do that. That Game Nods did not come up with this idea on their own and just use, instead of a chainsaw, but a ninja star to allow you to cut through fish. Or we have to show that they didn't do that. Similarly, in a practical example, when you're going to meet with a publisher, you're going to meet with a potential partner, a potential investor, and you don't want to give up your idea, you don't want to give up what you've created, and you don't want to give up your idea that's fixed onto whatever format and tangible media they fixed it onto, because that's how it gets protection. Something as simple as a release, a receipt. A lot of people will be asking for NDAs and confidentiality agreements, but something as simple as a receipt can actually go a long way. So when you're pitching an idea, you can turn around and ask for a receipt, and it's not always going to be accepted, because often you're going to have, especially in game publishers, they're going to sit there and they're going to say, we get ideas all over the place, and who's to say we're not going to get an identical or a substantially similar idea from someone else down the road? Or who says we don't have this, I haven't looked at your stuff, I don't know if maybe we're already in the works on something that's similar. So they do have a concern there, and that's fair. But for me to say you're not even going to acknowledge that you've got this from me, that's a little bit tough. So that's one of the methods, and I do get that question a lot. Is like, how do I protect it when I'm pitching an idea, when I'm pitching something? That is one good way of being able to try and protect. This one. There we go. So this was this brings up a really interesting issue in game design and development. The whole issue of game mechanics not being able to be copyrighted and protected. And there's a fair amount of background to why that would be. But when it does come down to it, there's a lawyer, a UK-based lawyer, Jazz Purewall, who's actually blogged and discussed the Radical Fishing game, as well as a couple of other games, and the whole notion of cloning games. He's discussed that online a fair bit, and that's one of their huge problems in the UK. I like to sort of focus on what he said here as well, because I'm of the same mindset that even if it's not, once you've put this original thought and effort and you've really created this structure, I would be inclined to think that a court will come in and say, yeah, I understand that. Well, despite the fact that we focus on tangible loss, that's a big word, isn't it? I'd like to think that the courts would come around and be reasonable and say, you put a lot of time, you put a lot of effort into this, someone coming in there and copying this, it sucks for you, and we shouldn't let that happen. And we'll find some way to enforce that. Unfortunately, it does cost a lot of money for you to actually, for the first person to get that done and to establish that precedent. And this is one of the, Jas was talking about having, one of the biggest faults is that someone has got to be the first one to do that. And I'd like to hope that the courts will recognize the effort and the time that goes into creating even game mechanics. Traditionally, in other medias and other entertainment medias in particular, you see music and audio. You have your audio and your visual, and these elements. It's something that everyone's familiar with, and everyone can see or hear, and they're very tangible. With game design and mechanics, it brings up this whole new area of the fact that the concept documents, the design documents, even code, someone could reskin and copy your design of a game and your functionality of the game, and you, the author of the original game, wouldn't necessarily even be able to recognize that. And that's something that it's very new to law, and it's quite frankly very new for us, even as audience members. If you have a side-scrolling guy running and jumping up and down, and someone was to take your design documents and use the exact same functionality, instead of it being put into a side-scrolling adventure-type game, it's a three-dimensional ball or car running through a maze, or driving through a maze, or rolling through a labyrinth or something like that. You still could have that exact same functionality of having to push these buttons in this sequence and at this time in order to complete the level. And the author of the original might not even catch that if they're just playing the game. And that's something difficult for people in the industry to appreciate, never mind a judge who's not necessarily that familiar with video games or the like. So it is a very difficult notion to have to deal with. So what do we do? What can we do when we have all these problems? Like we were talking about before, establish the copyright and establish the access. Register it, make sure that you take your precautions, you try and get that receipt, you show that access. At least that way you will have, while not a fail-safe route to take, not a fail-safe protection, but hopefully it will discourage someone from going and copying or taking your IP and your knowledge and your work and treating it as their own. Hopefully it'll be it will discourage them from doing that, because it's a messy situation otherwise. What happens if they do despite that? You will write a letter and you'll ask them to cease and desist, and they'll usually go with a little back and forth, and hopefully you can get things stopped there. We're not the United States. We're not. Our legal system isn't structured the same way that we award huge amounts of money to anyone who does something bad. Whether it's burning yourself with a coffee or putting your cat in a microwave, I think was another one. We don't reward stupidity. I mean, we don't reward, people on that scale. We look at the damages. We look at what the person actually lost. What did you lose out? What can you show that you lost? And then maybe we'll sprinkle a little bit of icing sugar on them. But generally, it's not even enough to pay for your legal costs. So it's really difficult. Another avenue, this happens to you guys, I hope it never does, but if it does, you have to be a little careful about this, but you can take some of the non-traditional routes. I worked on situations with clients where there was a contested property, Facebook was approached, boom, the site goes down. That can be very effective, but the risk you run when you do that is that the other person says, no, it was all mine, it was all original. I had nothing to do with, who? What? Radical, what? Extreme, no, I don't know what you're talking about. And if they have I have to be careful with the word you use there. If they have someone or if they are someone who's ready to turn around and play hardball, so to speak, they could theoretically turn around and try and sue you for interfering with their business and causing them to lose money because their Facebook page went down and they all of a sudden stopped selling the game and the game was creating X amount of revenue per month or per quarter, and they'll be able to turn around and say, here's the exact amounts, and it's very traceable, and if a judge looks at that, they'll be like, oh, that's easy. That's not what this is all about. So it is an avenue, but you just have to be sparing and you have to be careful with how you use that. IP in general, has everybody played Limbo? And everybody familiar with the situation, or I'm going to bring it up anyway. So Playdead Studios created an awesome game, and they discussed with the PlayStation to put it in the PlayStation Network, to release it first on PSN. And PlayStation was demanding that they keep the IP, that PlayStation gets the IP, and Playdead were good, strong, gutsy developers, and they said, no, screw you, dude, we're not doing that. They eventually released it on Xbox Live Arcade, and 300,000 downloads in the first month. Eventually it hit about 1 million. PlayStation Network, very interested, finally gets it, does well on PlayStation Network as well, but it could have done way better. They would have loved to have it released. So Pete Smith, who is I think a EVP at Sony, gave a discussion, and he was talking about how it can be justified that we just want to protect our investment. Really, we don't want to be harmed. There's a lot of ways to do that. You don't have to take IP. Absolutely. Publishers can invest a lot of money and a lot of time and a lot of resources in helping a property get to market, but there are numerous ways of them protecting their interest, and it doesn't have to be ownership in the IP. I don't know if any of you guys, can we just have a show of hands, who has worked on a convergent property or the interactive component of a television property? And so a few. And these guys are constantly turning around and saying, we want, give it to me. We want your IP. We need it. Because they're used to the television and the old school way of doing things where we need ownership of the IP. We need ownership of the characters, we need ownership of the plot line, we need ownership of the story. Understandably so. The problem is when we're dealing with this IP in video games, just like we were talking about before, it's not specific to that story, it's not specific to that character, it's not specific to that plot line. And that's something that a lot of traditional industry players are having a really tough time grasping. And more often than not, I find myself having to explain, no, it's very different. No, but we want it. It doesn't matter if you want it. You can't do anything with it half the time either. You know, numerous examples like there's people in this room who have, you know, dealt with situations like this where a company who's contracted with them has tried to alter, manipulate, update, change the IP that they've had, and they come crawling back and say, well, yeah, we can't do it. Can you please help us out? And we've already wasted this much money, so can you please do it cheaper? No. If you want it done, and if you want it done right, open your eyes, take the spanking like you're a big boy or a big girl, and learn from your mistakes. I would love it if that happened all the time. It doesn't, but it's you know, we're in a really tricky position here. It's you're on the cusp of this very, very big change, and we're finding that we have to educate a lot of the players that we have to do business with, and it will get better. It always does, but right now it's a very, very challenging circumstance. Now, I've completely digressed here. So when you guys are as individuals operating and preparing or getting agreements in place, we're going to talk about how you get copyright from someone. So transfer of copyright, in order for it to be an actual transfer, it has to be in writing. And one of the ways they do this is an employment agreement or a contract with an independent contractor, etc. And we'll throw in this language which will reflect, in Canada we call it in the course of employment, in the United States we call it work made for hire. And essentially the essence of that is, yes, you created this while we were paying you to create that, so you still have authorship over it, but we're the first owners. They're really complicated. All of a sudden, they're different concepts. Authorship and ownership. There's some inherent rights that you have as an author, like if you create big flying geese and they get hung in the Eaton Center, you can actually say, no, I don't want you to wrap little red ribbons around it, and please take them down now, or I will sue you. And I will sue you, and then I do win, and I get you to take them down. There are these moral rights that you keep as an author, which oddly enough in Canada and the United States you have a tendency to have to waive them. In Europe, you can't. It's a big challenge. But that's one of the distinctions between authorship and ownership. In these contracts you also see language about everything you do or everything you come up with, even if it kind of relates to what you're doing at the workplace, but it doesn't really, but it sort of kind of does, and it might relate to something that you talk to somebody about at the workplace. That's ours too, and we want it. You'll see a lot of this language in contracts, and I put it in a lot of mine that as reasonable as possible, but the gist will come down to it. It will be enforceable as far as it's reasonable. I think the best example is non-competes. Often you'll see a non-compete that's throughout the world for 5 years, anything in the entertainment industry. There's a little bit of a problem with that because yes, you need to be protected as an employer or the entity that's hiring the other person, but the other person really needs to be able to make a living. And we can't, the courts decided way back in the jazz music days that you couldn't really take that much advantage of these artists, these poor creatives that pour their heart and soul into things, and then you turn around and say, oh, don't worry, we'll take care of you, but you can never work for anybody again except me. They didn't let that happen, and so generally what will happen with these situations is they really can only be, if it comes down to it, they can only be enforced as would reasonably be required to protect the employer. Another common contract language that you'll see is confidentiality and non-disclosures. There's all kinds of different information, some of which is actually confidential, some of which isn't necessarily confidential, and they're treated very differently. When we go back to when we're determining a copyright infringement, just as you can determine a breach of any contract, it will go back to the damages. It will go back to what was actually lost. And similarly, when you deal with an NDA, whether it's as part of another agreement or as an agreement on its own, when you're giving a pitch or what have you, what are you really? You have to look at the essence of what you're working with, what you're working on. How important is it, and how crucial is it? Trade secrets, things that will give a competitive advantage, something that if it did get out would allow others to decimate your business, that kind of thing, you have to be very careful of. You don't want to be sharing that stuff. The fact that you worked on a project and the fact that your name was in the credits for a project and that project was released, and they still want you to be confidential about not talking about it? I don't know. It's out there. You put it out there, but you don't want me to talk about it? So there's varying degrees. Always things to be conscious of. One of the biggest is to look at what is confidential information, and if it's something that was put out there by the person to who it was confidential, so by the company that wanted you to keep it confidential, and they've already released that information, there's not a whole lot of damage that can come out of that. So that's this. I have. Is there any questions right now? Otherwise, I'll jump into other stuff. Yeah.
You mentioned a few times about copywriting certain mechanics or whatever. Are there any guidelines, sort of like unwritten or even written, to what to actually copyright, what you can and cannot copyright?
No. It's a very gray area, and it's still in being developed. What I would say is I would look at the fact that it's original. It has originality. It's original. It's this very, very cool new term that's coming out of Europe. It's all the rage.
Copyright it.
Yeah. Trademark, no. Good heckling, thank you. I look for originality. I look at expenditure of effort and time and skill, and that's what I would look at. I would compare it to data collection and a telephone book. If you're simply putting numbers in an alphabetical order, that's not original. It may take a hell of a lot of time. I'm sure it takes a real lot of time. And it takes a lot of effort, but that's not original. So it's that kind of thing. Does that help?
Yeah, actually, can I just follow that up too? With the fishing example you were giving,
Yep.
how would someone even protect themselves about finding out what copyrights were out there? Because they could always argue, like you were saying, I have no idea it was out there. Is there any way to go about checking to make sure your ideas have not been copyrighted?
One of the best ways is to register your copyright, and that will be deemed exposure. In the fishing case, the game was out there. It was playable. This person was in the video game industry. It was really similar. I think it's a no-brainer. Like, they would not have a problem demonstrating access. In other examples, you have, get you in 2 seconds. Film industry, there's numerous claims for every film that goes out there. No, you stole my idea. I had that, and it's on a napkin here from 10 years ago. And I came up with this, and you stole it. You did. You came into my house and you stole it. Good luck. Yes?
In regards to sort of NDAs, non-disclosure, that kind of stuff, and just basically protection, when it comes to larger studios, I know people who are working for some very large companies right now doing art assets and things like that. And it's pretty much their contractors, so it's their bread and butter. And they need to be able to promote themselves and say that they work for these large clients. But they're concerned that if they ask these large clients, they're going to get shut down even worse than if they maybe just slipped it onto their website when said product gets released. I'm coming from an animation background where every single animator who worked on any project, even big feature films, would immediately put said work on. I mean, they would always put the sort of the rough cut version on, not the final. They didn't cut it off DVD or anything. They put rough cuts on their demo reels because it was the only way they could get the next job at the next studio. But it was sort of like the unspoken rule that you kind of would put things that you weren't supposed to on your demo reels because it was the only way to get more work. What's the when it comes to sort of the breach of contract for the sake of self-promotion, where does the self-promotion stuff lie, and maybe how do you protect yourself as an artist or a contractor so that you can continue to self-promote, because without that you don't get the next contract usually. So.
That's a really, really, really good question. It's a really good point. And it's something that doesn't just face individual creatives. It also faces the developers who work with television production companies or broadcasters. Increasingly, you'll see that even with marketing and branding businesses and consultants and ad agencies who focus around branding, they want to take credit for everything. And it's a huge fight, and it means so much to the creator, and it's so belittled often by the person who's purchasing it or engaging it. We're talking about using like demo reels, demo clips. You're not talking about just simply credits, because if the credit's there and the name's there,
yeah,
I'm comfortable with that. Technically, no, you're not supposed to. I like to put it into agreements, and I think right up front, talk to them, say, hey, listen, I need to be able to do this. And it is standard. And there are arguments that can be made that, you know what, you should be able to put it down, even though it's copyright infringement, it can be defended under fair dealing and fair use.
yeah.
The problem is you don't want to necessarily get into trouble with that. You don't want to have to rely on that. But industry standard, yeah, you do end up relying on it a lot. But there's all these other points and things you can get into that I like to see in the demo reel clauses, and there's things that aren't even considered when you're working up front, like the ability to use a clip of it not only on your website, not only in that demo reel that you give to someone, but what happens if you're that super cool developer guy who gets approached for indie game, the movie, and we want to feature you and your work in it. Do you know how bloody hard it is to try and get a license for a clip to use in another property? It's unbelievable. And then, it's super costly. There is footage at the NFB that amazing footage that can never be put into a documentary and released publicly just because of issues with copyright. And so it's something we've been struggling with for a very long time. Just recently, the revisions to the Copyright Act have been released, and things like parodies are covered in here, and so we're getting a little bit better, we're getting a little bit closer, but we're still not there. We're still not at the stage where, wake up, this is a digital social generation, this is a digital social world, you have to be able to do this. It's, back in the day, it was, I got this wicked mixtape, dude, check it out, I recorded off the radio and it's awesome, it's this wicked song, you gotta hear this. Okay, that was one person giving it to one person. Now what happens? Oh, I'm gonna throw this onto Twitter, check out this link to this YouTube video I made, or that has this entire video from the artist. And how is that wrong if that's how we communicate? We're communicating in a very different way now as an audience, as a public. What used to be a one-to-one communication is really like a 1 to 10,000 if you're Emily and you have 10,000 followers on Twitter, or 1 to 5 if you're someone like me who's like 5 followers on Twitter. But it's a public sort of conversation now, and it's a public sharing, and that's something that it's going to be interesting to see how that gets dealt with. Ryan?
Oh, hello. We didn't talk much about trademark, but when you apply for trademark, there's a period of like about a year when it can't be contested. So I guess my question is from the other side, if you've got a registered trademark out there, do you have to have like a lawyer with like Doppler scope constantly scanning all pending trademarks every hour of every day? Like, how does that get picked up on if somebody tries to register something that you already have trademark or lay claim to?
I would love to answer that question. I'm not a trademark agent, so I will email you and ask a colleague who is a trademark agent and give you some idea on that.
How much of your time?
I'll do that for you. But no, I'd be inclined to think that you should, if you're actively using the trademark, which is what it's meant to protect, then you should probably be aware of the surroundings. And
Ryan, there's firms that actually do scout labs specifically to inform you that your trademark has been used appropriately. So yeah, like a lot of money. Nintendo, I used to blog, so Nintendo did that and got me on some picture that was a parody picture, and they were like cease and desist, etc. So yeah.
there's the answer. No, whether you're responsible, that could be the rationale for it, but we'll check. See, I don't know everything. Yes, red shirt and then green shirt.
This is more from the gamer's perspective, but gamers have been really carefully lately on specifically on this downloadable content, and I haven't got a straight answer from anyone. Is there any consensus on when somebody purchases retail products, what components of that they now own?
You own the disc.
Yeah, well, that's.
You bought the disc.
They'll say I bought
The
it.
information isn't yours.
Okay, so can you
Yeah,
specify
yeah.
what that means exactly?
You have a license.
Yeah, okay.
So copyright is like a bale of hay. Sexy. No. The reason we say that is because the horses poop. No. It's because if you have a big bale of hay, like you can imagine taking out a piece of straw and snapping it in like a million pieces and giving a piece to everyone else, and you always will basically have another piece of hay in this giant bale. Copyright's like that. You can turn around and you can give people the smallest or the biggest right. You can turn around and say, here, you know what, this bale of hay, it's yours. An employer will get the bale of hay minus the author's rights. Boom, yours, conveyed. You get to do whatever you want to with it, like any owner would if you actually owned it. But when you own it, you can turn around, you can divide it, you can say, okay, I'm going to give Danielle the right to use video game. We're going to give you the right to use this video game on the computer on the podium in room 308 of Metro Hall in Toronto from 7:30 to 9. And only when there's a security guard outside. But I'm going to give you the right to use the video game from 7 to 9 in Jack Astor's on any one of 10 different computers that they have there. So you can give out all of these abilities to use and enjoy. And that's what they're doing. They're giving you the right to use it, the right to play it, the right to enjoy it. Where it gets complicated is when you use it to make other stuff. When you play your video game and it happens to be Second Life and you've used it to make a really big house on an island and somebody else wants that. And they want to give you real ducats for it. That's where we get into a situation because who owns that new island? Who owns that big house that you used your time, you created, your original material, your original thought, your effort went into it? I'm going way farther than you want to go with this, right?
Maybe, let's see.
Okay. So this is where the issue will come is who's going to own that now. When it comes down to just playing the video game, you can play it. You can play it on whichever machine that will accept your disc. Arguably, you'll be able to make a backup copy of it now, and you'll be able to play it and put it from one device to another device. Potentially, as long as you're not sharing it with anybody else and not giving it to anyone else, because you don't have that right to give it to somebody else. You have the right to play it on your own machine.
Yeah, I'm not so worried about like user-generated content, but what if there's like other content there made by the developers or the publishers or whatever, and it's locked. You're paying $30 or whatever to unlock these characters or content. Gamer argument is always, well, I bought the disc, I should be able to do what I want with what I want that's on the disc. I mean,
So are you saying because the content is on the disc,
I think it's kind of a species argument. I'm curious as to like how do you break that down?
and they want you to pay more money to unlock what's already on the disc?
Yeah.
It's the same thing. I've given you this much of the hay. You want that much more of the hay?
Yeah.
You've got to pay for it.
It feels more like one of the arguments that here's this pile of hay, but you're not allowed to use part of the what that I gave you, as opposed to when I give you more hay. It's like you can't use that hay that I've given you yet.
I think it's two sides. It's two sides of the same coin. It's they're giving it to you. It's just at that point it's just a communication issue. It's just a I've actually put it on that disc. Well, don't worry. In 5 years we're not going to have discs. 3 years maybe we're not going to have discs anyway. It's all going to be in the cloud, and so you're going to have to pay for downloading it anyway. And so Hopefully that will answer, yeah?
No, it's just me, like, that's what it doesn't seem to be enough for a lot of cases, sort of thing. That explanation, a lot of people aren't really swallowing that.
Yeah, we'll carry this on
Yeah,
over beverages.
okay, sure.
Next.
I was wondering how important the various national divides are when dealing with some of these issues, because at this point, I mean, it is a very international industry, and then you have some big companies like Nintendo where they have a presence in the United States, they have a presence in Japan to deal with that. For like smaller people, like say in the iOS example, somebody makes a game, trademarks in Toronto, but then it turns out somebody who's challenging them lives in California. How does that end up breaking down? Like how much do you have to be aware of just the various countries that because these games get released in?
Trademarks are a little different than copyright protection. The trademark, you can actually be barred from using it there if they were there first. If they created it there first, using that, registered there, they will have that protection. But you'll have that protection up here, so they won't necessarily, even though they may have created it there first, you may have created it here first, they may not be able to bring it over here, and you may not be able to bring it over there. So how aware do you have to be? It's great to be really aware of everything. Practically speaking, I think it's very difficult. Maybe there's some government agencies who can one day help facilitate that awareness, and I don't know if that will be on to see or not, but who knows? Sorry, I think there was one question back here on that side, and then, yes, no? Oh, that was just a point to the cloud. Go ahead.
You're talking about employers and employees. Sometimes we have a lot of opportunities to do volunteers, and that's kind of employers and employee too. But sometimes I got some issues with the employers. But after the event, they neglected our concerns. So, is there any way to protect as a volunteer?
I'm not going to answer that question just because there's a lot of potential issues there. I don't know who it sounds like this may have potentially happened, may not have. It may involve a specific employer, and I wouldn't want to touch on that because I can't give any comment on something that maybe I work for the other person. In general, with volunteers, just like with an employment, what's in writing, what's agreed to, that's where the enforcement will come. So you'd have to show what's agreed to, and it would come down to what everybody agreed to when they started the relationship. Okay.
There's no contract.
Contracts can be written or verbal. It's just a heck of a lot harder to try and determine what the verbal contract was than it is the written contract. So it does, just because there's not a piece of paper, it doesn't mean that there wasn't an agreement. It's just a lot more difficult to try and prove that agreement.
Where can we look for help if you want to?
You can call lawyers, and there's a whole bunch of slides. Ask your friends who may or may not have dealt with lawyers, and call them up. They'll do a quick discussion about who both sides of the argument are and whether they can speak to you. Look for a litigation lawyer, someone who actually does that practice primarily, which is actually suing and that type of that type of adversarial situation, and that's one way of doing it.
You mentioned receipts. What's a pitch receipt look like?
It could be something simple like, sign here that I pitched you this idea. Ideally, what you want is you want to have a copy of that, whatever you're pitching affixed to it, just because it's a little easier.
Like a system, yeah.
Yeah, it can be a printed one. You can have a longer one. Have the date. Have the people who the person sign it, date it, write the name as well, not just a scribble.
Record a video?
Kind of thing. Sure, if they'll let you. Yeah, absolutely. A blood sample? Not so much. Is that good?
Yeah.
Okay, next. Yes.
Sure. Okay. I have a question kind of about like actually dealing with the lawyer. So you're saying for like your employment agreements and your NDAs and stuff like that, say like you want one of those. Now would I call a lawyer and say, okay, so this is what I'm doing, this is what I need, and they're like, okay, well, let me pull up a file and fill in the blanks, or do like you actually have to go in, meet them? Will it cost me all this money to sit down with the lawyer for all these hours to hammer out the specifics of these contracts?
Talk to the lawyer.
Oh, okay.
Each lawyer is different. NDA can be very, very simple, or it can be very, very, very detailed, like it can be a 30-page document. Depending on what you're looking for, that's what will be created. There are resources out there that have some templates. The risk you run with the template is not every circumstance is the same. It's particularly difficult in the video game industry just because it is a new and always changing industry. NDA, it's a little more traditional than some of the other agreements, but they are specific. But when you're talking to the lawyer, call the lawyer, ask them those questions. Say, hey, do you have an idea of how much this is going to cost? Do you have an idea of that? You should be able to get answers on how much it will cost without that costing you anything.
Okay, so like they should answer me if I just call and ask them that.
Yeah, if you say, do you have a flat rate for this? They may or may not. They can tell you how much they bill. You can ask them any question. Ask them, do you know how long it's likely to take you? You know, with enough information, they can give you a ballpark. The issue then comes around is an NDA is a little more, it's a little easier to deal with just because they call that an adhesionary contract. Has everyone heard that word? Adhesionary. That's when someone writes it, gives it to you, says sign it, and you sign it or you don't sign it, and it goes away. It's not negotiated, really, right? I shouldn't say that because NDAs, theoretically you can negotiate them, but generally they're not negotiated. So they are something that's a little bit easier to write and get done, and they can be more formulaic than a production agreement or a services agreement between, or a partnership agreement where there is a lot of negotiating back and forth, and you'll find that lawyers won't really say, oh, I'll give you a flat fee for negotiating this, because you never know what the other side's like and whether they're just complete or not. Yes?
Sorry, does client confidentiality cover something like, let's say I have an issue, I'm under an NDA from a company I've been making lots of art for, they're a challenging authorship or something, and in order to explain the case, I have to show you the IP, therefore breaching my NDA.
We're like priests.
Yeah? Okay.
What is said between a lawyer and a client is very, very, very protected. I think 90% of the time in that NDA or confidentiality provision or et cetera, it will expressly say that you can't disclose to any party other than your legal advisor and certain other people you have to. That being said, don't talk about it with the lawyer in the bar where everybody else can hear, because they may be protected the discussion, but if everybody else can hear it, they're not so much. But it's a good question. Now, what will happen, because I'm going to elaborate on that because I seem to be doing that a lot, hopefully it's useful, is you're going to have to, before you get into any of the details, the lawyer's going to want to know who the other side is, and so that they can do a conflict check and they can make sure that there isn't a difficulty, because if you were the client, you really don't want the other client coming and dealing with you and put you in an awkward position. So that's good. Yeah. Another hand? Yes, in front?
What's your opinion on Creative Commons licenses?
I'm sorry?
What's your opinion on Creative Commons licenses, whether they're single people or individuals or companies?
Creative Commons licenses for individuals or companies?
If you have
Give me an example of what you're.
Well, my game was always on Steam, but it technically has a Creative Commons license. It doesn't have an end user license or anything like that. Would you advise people say that's the dumbest thing you do, or have you ever run into a situation and either, either in a good case or bad case with that?
I haven't run into a situation. It's all going to be instance specific. It's all going to be what's your approach, what's your business model, what's working for you. Sorry, that's.
As long as you didn't just drop your face and say, what the hell did you do in order to do that? That's cool.
No.
Thank you.
No problem. Yeah.
Regarding pulling down generic NDAs from the internet and getting people to sign them, or writing your own contracts, not being a lawyer, how enforceable are documents like that?
Totally. It's the written document's the written document. What you want to look for is a clear expression of what's being agreed to. Yeah, the lawyer stamp doesn't do anything magical. It's just we have a lot of experience with stuff, and so we generally we often, not always, we often can think of things that the client doesn't, and sometimes the client's going to think of things that he'll be like, oh yeah, that's awesome. We have to start doing that. And especially in this space when things move this quickly, you'll find that you're learning from your clients often as well. Let's go right back here and then in front.
Yeah, I've been working on a game for about a year, and I recently found out it's actually a board game with exactly the same title. I'm pretty sure it's not copyrighted because it was made by a non-commercial organization, which is an educational thing. Should I be worried about that?
It's just the name?
The title.
Just the title of the game and the title of your game.
Does that matter? Or
look. You want to get into more specifics. Like that will require a little more than a yes or no answer. We have someone in the back nodding that yes, and often yeah. I think there are certain instances where the title, like with movies, doesn't necessarily have the protection, but it will be instance specific. Down here.
Yeah, sorry, this is a quick one I wanted to bounce off of Jason's question. What difference does having a witness signature make to a contract's validity?
I knew that in law school. That would be one of those things that I'd be, the client would ask, hey, what's the difference? And I'd say, yeah, I'm really busy right now. Let me get right back to you with that. So if you email me that question, I will not charge you for it. But if I do recall, there are certain instances where you do need a witness, and I think those are not all wills, but I think there's certain instances where witnesses are actually required. Otherwise, it's just sort of like a yes, we'll do that, and usually you'll see them. Yeah, it's email me.
Thank you.
No worries. And did we have another question over here? Yeah, go ahead.
I was just wondering how much you could protect with copyright. Is that simply for documents and anything written like that, or how would you go about protecting your actual software once you develop it?
Copyright and patent are slightly different. I don't touch patent. My understanding of it is that it's going to protect the process, and it has to be an extremely unique process that requires and warrants that type of protection. So it has to be unique enough that it makes a difference. Copyright, when you've created it and when it's got those elements of originality and time and effort put into it, it's yours. And when people say that, can you copyright by, I remember back in the day, you used to have this thing called mail, and I used to be able to put something in an envelope and it was written down, so that's the expression of the copyright. And I'd mail it to myself, and I'd get the post office. That's this like weird place that's now usually found in like pharmacies and travel agencies and stuff. Get them to put a stamp on the seal. That's what that's doing is it's not copyrighting your work, because your work's already copyrighted. it's already protected by copyright. What that's doing is it's demonstrating when you did it. And so in the case of an infringement, you can say, no, I had this idea, I had it independently this long ago. Doesn't mean that you can't have the same idea, but it just means that I had that idea. Yep.
Just on the same note about the when, given how the media is public to like fake blogs and all that stuff, how important is it to actually have like some third party control your like commission history for when you post that information?
Sorry, can you repeat that one more time? Sorry, there was I don't know if it's the echo or something.
Given how important it is for like we set up the post stamp on it, record when it was actually like mailed out and stuff, and how easy it is to take blogs and digital stuff and just change around. How important is it for, say, some sort of third party to actually keep track of your revision history for that kind of stuff?
It's that adds another level of certainty, another level of not even certainty. I guess you can't say certainty. I'm a lawyer. I don't use that word. It adds another level of protection to it. It's even more likely that you're telling the truth if you get a copy to your lawyer and they put it in your file and they've received it. Sometimes when that's another thing. Sometimes when clients are pitching an idea, they will CC me on the email, and not that it really changes anything, but at least it turns around to the other side and says, hey, there was a lawyer that was CC'd on this email, so he knows. Really, it doesn't change all that much. It's just, hopefully it's a deterrent, and that's what we're looking for, is to make it, we don't want to go to court. Like, you don't, it's something that you want to avoid no matter what Kevin on Dragonston says. You don't want to go to court. It's just, it's yucky. Now, this is coming from someone who's not a litigator, so litigators, if there's any here, sorry. That's how I feel. Personal opinion. So, so it's just sort of an added.
Like one of the reasons I'm asking is like I'm looking at the design document, but I put it on the Google Docs specifically because they have a revision history, and it's I can't control what they do when they're logging. So.
And you're worried about protecting your copyright and you're putting it on Google Docs? Because that's secure, right? That's one of the things that drives me nuts about the cloud, is that it's also really often not that secure. That's the conundrum. You want your stuff out there, you want to put your ideas out there because they're great and they're awesome, and you want everybody to see what you're doing, but at the same time, the more awesome it is and the more it's out there, the more likely someone might try and take it. So. Okay.
Can you copyright gameplay?
Like the mechanics?
Just general gameplay. I want my game to play like Diablo, or I want my game to play like Mario Brothers. Can you copyright the actual gameplay? Can you use copies?
Very, 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 very unlikely. Like I can't think of a situation where the gameplay would be protected, but that's not to say that there isn't.
So you can copy gameplay.
I'm not going to say no, but I'm definitely not going to say yes. Fashion industry, this year, there is this designer of high heel shoes that are supposed to be the sexiest damn things on earth, and some people here will agree with that. They have a red sole. Red sole. Can you imagine that? A red sole on shoes? How freaking brilliant! Red sole! Wow. Can you protect that? You used to say no. You say, are you kidding me? This is the fashion industry. We come up with colors every day. We come up with designs, and you can't copyright a color. You can't copyright that. Well, apparently when you're Christian Louboutin, it's a little different.
At what point does that become a branding issue, though?
Because that was part of the grant.
Up until the point where I think Yves Saint Laurent said, "Screw you! I'm putting a red sole on my shoe."
To be fair, he's dead.
So the company Yves Saint Laurent collectively, through their board of directors, decided to engage officers who made the decision via creative directors and managers to say, "Screw you! We're putting a red sole on our shoes." And then the court turns around and goes, "Well, Christian Louboutin, Yves Saint Laurent." I'm really hoping it's Yves Saint Laurent. It might not be, but
It was.
we're going to use. Okay, good. Yves Saint Laurent. Damn it! What can we do? Well, Christian, he deserves the protection, but I don't know why I got into French accent there, but it's Yves Saint Laurent, it can't be wrong, so when the whole shoe is red, it's okay to have a red sole. I call bullshit. Totally. So that would be my analogy. I'm not going to say that it wouldn't be protected, but it would have to be a really, really convincing situation, I think, for it to be protected. Or it'd have to be Christian Louboutin, or Yves Saint Laurent, maybe.
Like Tetris?
Ooh. Possibly. Possibly, but you'd have to, you know, you change the shapes. Does the gameplay? Obviously, it didn't get completely protected because there's been millions of different incarnations of it. Bedazzled or bejeweled, sorry. You know, there's bedazzled. I had one of those. I think we actually are we going to be booted out of here, or can I take these last two questions?
Shortly, let's take the last two questions.
Okay.
We've got some wrap-up notes.
Okay. Yes. Yep.
In your last example, the red soles,
Yes.
I can tell you I had a pair of cons with red soles long before any of this happened. So how can somebody copyright something that somebody else had already had in production?
Again, I think that whole thing was bullshit. That's yeah. We can talk about how copyright can overlap on other copyright if you want at the bar after. Go ahead.
How can you tell sort of the line between, say, copyright and, say, patent? Because as Ryan, the illustrator, talked about, there's a Sega patent on a little directional arrow that they use in Crazy Taxi, where you can't use that in other games. That's if you play like Grand Theft Auto, there's a reason why there's no arrow above your head, because Sega was a patent on that. But that's a patent issue, not a copyright issue. So what sort of, you might not be able to say copyright gameplay, but what about patenting, and where would you be able to recognize where that line is drawn?
It would have to be so unique, and it would have to contribute in the way in which patents contribute, that a patent agent would be able to give you like a really good explanation on. That would make it worthy of that type of protection. Yeah, that's.
So that if you were to say, protect Tetris, that would probably fall under patent law.
Yeah.
You could tell if there was a patent filed, right? So they're all filed. So if you're looking to see if something is patented, it's filed under the USPTO or whatever it is.
But that's only a patent.
What's that?
That's only a patent state.
Well, they could. I mean, there are international patents, right, Emmanuel?
I'm not sure about that. I know that there's agencies that represent
Okay, well, at least
patents,
in the States then, I guess, right?
And again, like how much would it cost to find out all the places where it's patented?
quite a lot probably. It's cost prohibitive, often. Okay, so I'm going to quickly do my thank you, and I'm going to let Danielle do it. So thank you to Danielle and Emily. Emily, who came up with amazing current examples. Danielle for putting it together. Thank you to the steering committee for making this happen and making contributing so much to the developers of Toronto. Tim for just such a wicked poster. Thank you. And then thank you to Ubisoft of Toronto, City of Toronto, Big Viking Games, Get Set Games, Massive Damage, and thank you to all of you guys in this wicked game community and development community in Toronto. Thank you guys. Contact info.
Thank you, Emmanuel. That was great. So we got to wrap up pretty quickly, otherwise he's going to kick us out. So I just have a few announcements. We've got a lot of stuff coming up. This was just a list of things that I got very quickly, so I might be missing some stuff that's happening in Toronto, but just to let you know, there's going to be the Gamer Camp and IGDA holiday party next Thursday. That's at Pacific Junction Hotel. Check Facebook. Everything I'm going to say is check Facebook, so I'll just stop saying that afterwards. Then there's a Hand-Eye Society the next day on Friday, December 7th. And just a reminder that there's a skill swap every Friday at George Brown College, so speak to Randy if you're interested. And then something that I've been asked to announce, so there's a few games made by your local developers. So there's Drawkin with Probability Zero. And Little Guy Games, their game is coming out on Wednesday called Super Snack Time. And oh, I forgot one more thing. So in January, we've got the Global Game Jam, and that's going to be with Troy and Randy again, and IGDA is an official partner for that. So that's happening the last weekend of January 25th to 27th. Registration is not open yet, so they're just figuring out some of the last few details, but if you're interested, just keep your ears peeled. Your ears peeled, your eyes peeled, your ears, anyways. And one other thing, so Alex Hayter, who is a member of the IGDA committee with us, he started an IGDA TO Steam group, and they're doing a Counter-Strike global offensive tomorrow night at 8 p.m. So if you want to game with some of your fellow Toronto developers. And I think you want to try to turn that into like a weekly game night or something?
If everyone turns up tomorrow, it'll be a weekly thing.
A weekly thing, different games every week. So, please help us clean up. So if you see any cups, cans, dishes, just put it to the side. Everyone should have a survey on their seat or around them. We would love it if you filled it out because we really do use those to help make these better. And join us up the street at Jack Astor's on John and Richmond. And that's it. Thanks, guys.